Hi, so today in this video we're going to be talking about some fundamental concepts in land law. I'm going to quickly recap on what is meant by an estate in land before having a little bit of a closer look at the difference between personal and proprietary rights in land law. Okay, so first of all, the estate in land. Now, all land in England and Wales is vested in the Crown itself. Okay, it is therefore impossible for you or me to actually own the land, own the land itself. So in 1066, William the Conqueror conquered England, and one manifestation of this was that he became the owner of all the land. This brought about a conundrum. If he owned the physical land, then what could the people own? The answer is provided in the doctrine of estates. So, although we can't own the land itself, we can own an estate in land. That is, the right to use and control the land. Textbooks sometimes define an estate as a right to use land for a definite or prescribed period of time, although this can be misleading. The doctrine of estates is the idea being that although we cannot own the physical land itself, we have a right to enjoy, use, and control that land. And in modern day, the only remaining legal estates in land are the estates in fee simple, absolute in possession, which you may know as the freehold, and the term of years absolute or leasehold. And you can see that in the Law of Property Act 1925 in section 1. And historically, there were more than these two legal estates, but today you only need to worry about the freehold and the leasehold. Okay, so it is possible to have even smaller rights over land than the freehold and the leasehold, and they will affect the freehold or leasehold ownership and the way in which that land can be used or controlled. So these are different rights affecting an estate in the land itself. So for example, let's say that we have Claire, who owns the freehold estate in Blackacre. Her estate is then subjected to the following rights. We have Liam, who lives next door in Whiteacre. He has the right to use Blackacre's driveway to access his house. We have Richard, who lives on the other side of Clare in Blueacre and has the right to prevent Clare from building on Blackacre. And then we have Katie, who has the right to use Blackacre's field every Thursday morning to host a farmer's market. So these are three very different rights that individuals have over Clare's land, and they are rights that affect her freehold estate or her ownership in Blackacre. So although she has the estate and land itself, there are other smaller rights that can impact her enjoyment or use of that land further. So what is the difference? It's a very critical distinction to make here between personal and proprietary rights. Now, personal rights or rights in personam affect only the parties that originally created the right. So let's say X here. So looking at the diagram below, X, like Claire, is the owner of a freehold estate in land. Now let's say X and Y agree between them that Y will have a right over X's land. Then let's say X then sells the land onto Z. Okay, he's the purchaser of the fee simple or the purchaser of the freehold. If the right X and Y have agreed to is a personal right, okay, that right will therefore have no effect on Z under any circumstances, okay? A personal right will only affect X and Y. So X and Y in the creation of a personal right will not bind the subsequent purchaser of the fee simple, the subsequent purchasers of the freehold in that land. Okay, proprietary rights or rights in rem or interest in land are capable of affecting third parties, and this is a great innovation of land law. So if X grants Y a proprietary right, so a right in rem or interest in land over that land that attaches to the land itself, so if X grants Y that right in rem, what this means is that when X sells his land onto Z, okay, this right is capable of binding Z, okay? So be aware of this word capable that I'm using here, and I got it italicized on the slide itself. If the right granted to Y is a right in rem, it doesn't mean that it definitely binds Z. Whether a proprietary right does actually bind this Z, the purchaser of the fee simple, will depend on a further set of complicated rules which I will discuss in a later video. So these bubbles here are different rights in rem that we can have. They are different proprietary rights. Now each of these rights in rem has its own set of content requirements and criteria that need to be satisfied. So for example, in order for a right to be a lease, it needs to grant exclusive possession of a property for a fixed maximum term and arguably in exchange for rent. You cannot label a right as a right in rem, which has a third party impact, without fulfilling these criteria. So for example, if I grant you a right of non-exclusive possession of a property and label that a lease, that will not have an impact on a purchaser when I sell the house on. If the criteria is not fulfilled, then you do not have a right in rem. It becomes a right in personam, a personal right instead. So therefore, any other right which is not in the above bubbles is inevitably a personal right, a right in personam. Now, numerus clausus is a crucial principle of land law. It dictates that rights in rem, proprietary rights, are limited to a finite subset. So they are limited to a finite number and ensures the number of these proprietary rights remains small. This is because allowing a right in rem to have effect can necessarily cause harm, as a purchaser may be bound by them even if they do not agree to it. However, rights in rem do actually also deliver a benefit. Whilst they harm the purchaser of land, they obviously benefit the rights holder. So for example, Liam, in the example that we showed you before, having a right to use Blackacre's driveway. Imagine Liam couldn't access his land without this. It is going to be very important to Liam that his right can be protected. If on a sale of Liam's right over the land was defeated and couldn't enforce it against the purchaser, he would be in a lot of trouble, as you can imagine. So the law's project is to balance detriment and benefit. So although there is an unavoidable and inevitable detriment, there is also often a benefit. So the law's project means that a right in rem will only be granted when the benefit outweighs the inevitable detriment. The bubbles represent situations where the law has decided that the benefit of allowing a right of that content to endure against third-party purchasers of land outweighs the inevitable detriment. Okay, so that was a very quick recap and a very quick overview of estates and land and the differences between personal and proprietary rights. If you have any questions at all, please just leave a comment below and I'll get straight back to you. Thank you very much.